Cool. So let's make a start. A really warm welcome to Meet Business Women, Ask the Legal Experts. I'm Laura Ryan, Chair of Meet Business Women, and we're trying something really different this month. The last couple of months, as you know, we've really focused on personal development. And this month, we had the idea to try something different in terms of asking the legal experts. And this idea came about because of Amanda Butelaar at Dovecote Park is connected to Bryn, who I'll introduce in a second, who works for HCR Legal Experts. And they very kindly offered us 4 of their team that can answer any of our legal questions and chat to us today in an informal setting. So really keen to get plenty of interaction going through the chat. And I'll hand over to Bryn now, and you can just tell us how the session's going to work, if that's okay. Thank you so much, Bryn.
Yeah, thanks very much, Laura. I'm absolutely delighted to be here with my colleagues from HCR and to obviously link up with Meet Business Women. My name is Bryn Thomas, and I'm a partner in the dispute resolution team based in the Cardiff office. The format is a question and answer webinar, and we'll be answering the questions that you've submitted in advance and also live during the webinar itself. Thank you to everyone who submitted questions already. Please use, as has already been indicated, the question and answer button to ask further questions at any stage. If I can introduce my colleagues, answering your questions are our legal experts. We've got Robin Coolhoven. He's a partner in the restructuring and insolvency team.
Good morning.
We have Chris Mayers, who's head of employment and immigration in Wales, based in the Cardiff office.
Morning, everybody. Morning.
And we have Dan DeSaules, who's a solicitor in the commercial department.
Morning, everyone.
And of course, you've got me. In terms of, we might as well crack on with the main sort of stage of proceedings. So in terms of the questions that we have, if I could start firstly with you, Robin. Got a fairly short, sharp question, but pretty key actually for businesses, especially in the current economic climate. How should we manage our cash flow?
Right, brilliant. Well, thanks for the question. Always great question to start off with. Cash flow first thing in the morning. Everyone wants to talk about that, obviously. To set the scene, the reality is, of course, that we've had quite a lot of help with cash flow over the last few months because of the pandemic. Government assistance with the cash flows consisted largely of the furlough scheme, but that's now a decreasing benefit, and the real benefit of that will come to an end over the course of the next month or so. There's also been CBILS, which obviously is effectively the kind of interest-free period on certain loans that you can get to assist your cash flow and also underwrite your working capital. The key, of course, now is that we're coming out of furlough, and coming out of furlough means that there'll be an awful lot of new business pressures. So we've got the furlough schemes, as I say, coming to an end. And I think an awful lot of people will have learned from that furlough scheme that actually they might be overstaffed. So the reality is that we need to keep a careful eye on what our supply chain, and also our customer chain is doing. In terms of our customers, it's all about intelligence, really. It's about our intelligence and understanding of what our customers are up to. We need to be doing credit checks, but most importantly, actually, and this is really where sort of Meet Business Women as an organisation and the various sort of industry bodies can assist. It's about sharing information between each other, making sure that as suppliers we're talking to each other so that we educate each other and protect the businesses of going concern for everyone. So it's about speaking with other suppliers. It's about comparing experiences. It's about creating shortlists. Improving cash collection is the easiest thing to say and possibly the hardest thing to do in many ways, but it's about communication with your clients, about making sure that payment schedules are adhered to. It's about being tough, and it's about addressing your terms and conditions. The meat industry is different to a lot of other industries that I come across, because you don't have certain protections like retention of title. You can't operate retention of title quite in the same way when you're talking about perishable goods. Because in reality, retention of title is all about being able to identify what you've supplied and taking back what you've supplied in the event that bills aren't paid. So you don't necessarily always have the luxury of being able to rely on certain terms and conditions in the contracts. So it's about educating your staff about what the key outgoings are, about recognizing the warning signs. So look at for instance, the periods over which normally clients or customers are paying their bills, see whether there are any changes in that, speak to them. The worst thing that can happen here is not addressing the issue right at the outset, and then put them on very strict terms. And the reality is, you may need to move people from standard terms to cash on delivery, for instance. So payments on account, no extended credit, and effectively what you need to do for cash flow obviously is the obvious thing, which is extend payments out and shorten payments in. So the reality is, it is about speaking to your customers, speaking to your fellow suppliers, and helping educate each other to protect the industry as a whole. There's no ready-made answer to this. It very much depends on how hands-on the people in your organization are in the way that they manage the clients and the payment schedules.
So communication, as you say, and being proactive to meet the problem head on. Obviously, the meat industry is quite unique, so that's vital, really. Yeah,
I think the retention of title point is, for an awful lot of suppliers, that's a really good form of protection, because if a customer knows that if it doesn't pay, there's a good chance that the goods will be taken back. That's a powerful tool, but that's a much more difficult tool in this industry because, of course, first of all, you've got perishable goods. Secondly, while I'm obviously not an expert, as the guys in the meat industry are, the reality is that it's identifying the goods is also the key issue, because people you supply to will often take identifying marks off. So you've got to be proactive, and you've got to nip it in the bud effectively. So early warning signs and instant reaction.
Thanks very much, Robin. That's really, really interesting, really helpful. Dan, if we could move on to you, please. The question that we got submitted here. Do I have to vary existing contracts, or can I not simply terminate and enter into a new contract?
Yeah, thanks, Bryn. I mean, in a nutshell, of course, as parties to a contract, you're free to do what you like, obviously depending on the wording of that contract. Obviously, the benefits of a variation, and we've probably seen this quite often, obviously given the pandemic and how that's kind of changed the industry as a whole, and of course, thinking ahead, obviously we've got Brexit on the horizon. So variations, or the benefit to variations, very much keep the original contract alive and kicking in terms of the parties' original commitments, which is always good. That said, obviously if there are several amendments or variations to be made to the contract, which could change the general scope or the overall nature of the contract, then perhaps it would be more beneficial entering into a new contract and obviously terminating the existing one rather than a variation. But there's a couple of caveats with that, and I think the main one that people can kind of forget about, or what's often slipped through the net, is the fact that sometimes termination payments could be due on basically the trigger of terminating the contract. So that's the first point to kind of check in your contracts if you're going down the termination route rather than the variation route. But as is always between parties, if you are entering into a new agreement, then actually can that be waived between the parties? Can there be an agreement for any termination payments to be discussed, any compensation to be paid, and parties to effectively have a clean break? Other provisions to look for if you are sort of varying the contract or terminating is do you have to give notice? Can the contract be terminated immediately, or do you have to give, say, 3 months notice? If you do have to give notice, then does this have to be in writing? Does it have to be served on the other party's registered office address? Those little nuances are very important, and actually if they're not adhered to, it could actually mean that the termination or even the variation can be invalid. But I think there's probably a wider issue here, and I think whenever you sort of talk about terminating contracts, I think that's always a scary proposition for both parties. And I think the focus should be on preserving that commercial relationship. At the end of the day, that's why parties entered into contracts at the start. So I think, first of all, transparency is key. So identify what the issues are with the other party rather than jumping straight to termination, for example. If simple things can be varied, so if you're talking about supply, do they need to be decreased going forward? Do there need to be price mechanisms agreed, prices dropped, or does there need to be some kind of Brexit proofing in that contract, thinking ahead. So I think always identify the issues and perhaps come together with either other counterparty to produce an issues list. Like I say, if things can be worked out practically rather than going down the legal route, then of course that's more beneficial. But on the flip side of that, of course, if you are changing things such as pricing or minimum delivery terms, for example, then of course that would always be advised to be put in writing, and therefore obviously stick to the variation clauses of your contracts if they're on there.
Thanks very much, Dan. I suppose there's a tendency, is there not, to sort of stick to the black and white of the contract and act on that and the structure of that, as opposed to talking is incredibly important as well. And you touched on the issue of on the matter of an issues list there. I suppose there's a general reluctance for people to do that initially, but it's so important.
Yeah, definitely. And I think it's one of those where if you've got multiple contracts in place, of course that does seem like an initial administrative burden, but I do think longer term that's definitely the right way going forward, because of course that commercial relationship and the preservation of that, I think is the key thing. It's one thing having a legal contract that says one thing, but of course, as we've seen with the pandemic, practically the industry's changed. So actually, how does that effectively work on the ground now between those two parties, and how do you keep that business relationship going forward?
Yeah, sure, that practical commercial reality, isn't it, really? Thank you, Dan. Chris, moving on to the sort of employment field with yourself, with a question submitted here. How much notice do you have to give for a redundancy? And the second part, how do you calculate the payment? If you could kindly provide some input on that.
It's a slightly ambiguous question because there's a number of aspects you have to consider if you are to make employees redundant. Firstly, you obviously have to follow a fair and reasonable procedure. But what some people forget is not only would a redundant employee be entitled to the statutory redundancy payment, but they'd also be entitled to their normal contractual notice pay. The reason I say that the question is slightly ambiguous is that if you are planning on making more than 20 redundancies within the next 90 days, then the collective consultation requirements kick in, and you absolutely must then engage in proper formal collective consultation with the affected employees. And if you don't, any employees who have been made redundant without proper collective consultation can individually then go to the employment tribunal and claim what's known as a protective award, which is up to 90 days further pay, basically as a punishment for the employer not to go through collective consultation, in addition to the statutory redundancy payment and in addition to the contractual notice pay. So if the question relates to how much contractual notice do you have to give, well, obviously the answer to that is look in the contract, see what the contract says. If it's unclear, then you fall back on the statutory position. And the statutory position is that you get 1 week's notice pay for every year you've been there, up to a maximum of 12. So if the contract doesn't say, then it would be 12 weeks notice pay, the statutory redundancy award, and if you get it wrong in terms of collective consultation, it could end up with another 90 days pay. In terms of how you calculate the redundancy award, the honest, straightforward answer to that is there's a whole series of online calculators. And it's as well to use those because the redundancy payment, the statutory redundancy payment, is calculated by reference to how long you've been employed and your age at the date of dismissal. And then it's capped at a particular amount, which from memory at the moment is £585 per week. So for the first few years, the multiplier would be half. For, I think, between 21 and 41, you use a multiplier of 1. And beyond 41, use a multiplier of 1.5. So the easiest thing is just use one of the online calculators. You put in, obviously, when somebody started, when they finish, what their age was when they started, what their age was when they finished, and then the online calculator will do it for you. They're available on the government website. They're available on the ACAS website. So that's the easiest way to do it. That's the 3 essential points to bear in mind. And the other point I'd emphasize is in considering redundancy, of course, it can be because you're completely closing the business, or it can be because you're just closing one of the workplaces or partially because in one of the workplaces, or because there's a diminished requirement to do the work of a particular kind. So there's sort of three bases on which redundancy might come into effect. So it's always worth bearing that in mind. The other thing I'll say, Bryn, before I finish answering the question, is that HCR have done a series of webinars specifically on different aspects of redundancy. There were 3 hour-long webinars which are available on our website. So certainly if any of you are likely to be involved in redundancy, and I suspect you are because of the nature of the economy, then it's certainly well worth just spending a cup of tea and watching some of those webinars. But equally, if you've got any specific questions you'd like, you're welcome to ask them now while we're all here, or to contact us after the webinar by email, and we'll gladly answer them.
Thanks, Chris. There is a sort of a third aspect or part to this question, which I guess you'll advise is a bit of a no-no from an employment law perspective. But it has been asked, how soon after you make someone redundant can you employ someone else in a similar role? And I think that would probably best be avoided.
Well, full marks for spotting it, yeah, because quite clearly, if you make somebody redundant, I mean, the entire legislation is set up basically to give employees protection, but to avoid redundancies where possible. So as part of any consultation, whether it's an individual consultation or a collective consultation, the employer must explain why it's necessary to make redundancies and why they can't be avoided. And there's also a further requirement that any employee at risk of redundancy should be considered for suitable alternative employment within the organisation. And there's specific provisions relating to that. What would be very difficult for an employer to defend is a situation where they've made somebody redundant and then shortly afterwards they've appointed somebody else to the same role, because clearly then from my perspective, if I was acting for that employee, it'd be very easy to go to the employment tribunal and say, well, it was never a genuine redundancy because they've replaced somebody. So it is a bit of a no-no. The only obvious caveat to that is if there is an appreciable period of time between somebody being made redundant and then somebody being replaced, that might be objectively justifiable. There is also a practical point, which is that if you're bringing a claim in the employment tribunal, the time limits are very short, and it's basically 3 months from when you lose your job, subject to a little bit extra few weeks because you have to go through ACAS early conciliation. But once somebody has gone past that time limit, they can't then bring a claim. So the strictly legal answer would be, once the time limit has expired for somebody to try and bring a claim alleging unfair redundancy, you could probably then replace them, and that dismissed employee would be out of time in bringing a claim. So it's risky. It's certainly risky, I would say, within the first 6 months of somebody leaving. But after that, businesses move on, economic circumstances change. You could probably justify it at that stage, but I certainly wouldn't try and do it in the first 3 or 4 months. It'd be far too risky.
Okay, thanks very much for that, Chris. So moving on to the health and safety field, we had a question submitted. Do we need external health and safety risk assessment for everyone's homes, or is there a template that they can complete and keep on record? And essentially, employers obviously owe a duty to take steps that are reasonably necessary to ensure the health, safety and welfare of all employees, and that's to provide and maintain a safe system of work, including obviously employees working from home, which is fairly commonplace now across the sector. Employers have a general duty, obviously, to conduct a risk assessment of all the work activities carried out, and that's to take appropriate measures. Employers are not excused from those health and safety requirements just because the employee is working temporarily from home. So that's obviously important to bear in mind. And many employees, of course, will be making do with their setup at home, and that could well be less than ideal. It's not practically possible, and the law obviously recognises that, for employers to visit employees' homes. It's just simply, it's not going to happen in order to carry out individual risk assessments. But you can ask employees to undertake a self-assessment, for example, by using a simple checklist, and there are many of those appropriate checklists available online, which can give input pointers and signposts to employees to conduct the appropriate assessment of the home environment. So there's a lot of information and material out there which can assist businesses to do that. If we can flip back to you, Robin, now, in terms of your field, the second question that we had submitted, are all cash grants subject to tax? Right,
from cash flow to tax.
Yeah.
It's a joyful life I live. Okay, in terms of grant, obviously, it very much, I'm working on the assumption here that none of our members are going to be charities. So obviously it depends very much what it says on the wrapper. Effectively, if it is a grant for a non-trading activity, then there's a very good chance that it would be exempt from tax. But first of all, I think it's highly unlikely that the majority of our members would be expecting to receive a grant for a non-trading activity. So broadly speaking, the vast majority of grants will actually be included for the purpose of calculating corporation tax. So the expectation would be that a grant would be taxable to chargeable to tax, I should say. What I would recommend, obviously, first of all, is establishing exactly what the rules relating to the grant are before you apply for the grant, and also I would recommend running that application past your accountant to make sure that you're getting the maximum benefit out of that grant and not losing any more to tax than you need to. But in reality, of course, it will be treated by HMRC very much as another taxable form of income. So the general rule is yes, you would expect a grant to be included in calculating the corporation tax at the end of the trading year in which the grant has been received.
Okay, and I suppose that's a key point, isn't it? You see these grants available and there's a tendency to jump in and not necessarily check what the conditions surrounding those are.
Well, yes, it's like all things, isn't it? I mean, small print is generally ignored. And of course, the reality is people are applying for grants usually because, there's a need for them. So yeah, the urgency to obtain the funds is actually quite often a more important factor than checking what the long-term effect of that grant might be. But then if you go back to the cash flow argument, the reality is it's better to have the money they're not, particularly in difficult circumstances. So I don't think anybody can blame for not reading the small print, and we all do it from time to time, I suspect. So, but yeah, there are rules there, and your accountant should be best placed to give you handy advice, particularly in relation to your business, as his understanding of your day-to-day business will obviously be a key factor in determining whether making the application is appropriate.
Brilliant. Thanks very much, Robin. Dan, coming back to you now with a second question which we've had submitted. What should we do if we don't have enough resources to fill customer contracts rather than resorting to terminating or varying?
Mm-hmm. Yeah, it's quite an interesting one, this is, and I think obviously leading on from what I said to go about always communicating issues to your customers from the off. It's obviously useful to be aware of any sort of legal arguments which may be forthcoming. So if you've got numerous customers, and obviously you're a supplier in this situation, and you're struggling to fulfil your customer orders, given what's happened in the pandemic or whatever might come, obviously in the future, there's three main options really, and they're probably all practical, but I'll come on to the legal nuances in a moment. So you can obviously under-deliver to all those customers equally. You could complete deliveries to certain customers in full and kind of default on the remainder of those entirely, or you could adopt a mix of those two approaches. So I think the decision ultimately depends on the supplier's appetite to risk and obviously how its relationships are with certain customers. But I think the kind of legal factors and general factors to be aware of are there any clauses in your contract specifically which require you as a supplier to specifically allocate resources to a particular contract? So we've seen that type of clause or I've seen it across a lot of industries where it's almost like a preference contract where you've got a bigger customer, obviously from their point of view, wants that security of supply. So they insert a clause which basically says, in the event that there is a shortfall of supply, you will give preference to them in the interim. So that's always one to look out for. The other factor is a general good faith obligation. So is there a good faith obligation in your contracts, which again may require you as a supplier to give preference or at least strong thought to a particular customer, as opposed to other contracts which may be more informal and obviously without a good faith obligation. Won't bore you with good faith, but that's pretty much a US dominated term, which is starting to have more an effect in sort of English and Welsh law now. But historically, good faith wasn't really sort of lent upon too much from the courts in this country. But like I said, that's changing. So it's always good to check whether there are any good faith obligations in your contracts. And the third one, probably the biggest factor to be aware of, is minimum obligation for delivery. So, do you have to, as a supplier, supply a certain minimum amount to customers? And obviously, are you going to be in material breach of that if you don't hit those figures? Which, could obviously result in the customer having less supply, and I think more to the point, give them appetite for potential litigation against you. And as I mentioned before, sort of first and foremost, transparency is definitely key. So if there is a problem, if you can see it coming in your pipelines, contact your customers as soon as possible. More often than not, in my experience, I've seen that if you take the ball by the horns, you be proactive, you communicate to your customers, they're probably less likely to sort of come after you, so want a better word, when things do turn sour. So that's always the first step. But I think failing that, probably the best advised approach would be not to kind of prefer any one customer or particular customer if you've got a portfolio which you're going to be under delivering to as a supplier. So in taking that approach by delivering to your customers all equally, albeit potentially smaller suppliers than you would normally, what that will do is that will ensure that if there is a claim against you, it will be for damages only, rather than if you don't supply anything under the contract, then obviously that could result in the customer having a claim for repudiatory breach of contracts, which is obviously so material that it goes beyond what the parties agreed in terms of you supplying them with goods, then paying you for the goods. So what that does by just providing that minimum amount to your customers is you avoid that argument of then the customer saying, well, we're terminating the contract for repudiatory breach. And that again goes hand in hand with that principle of trying to preserve that commercial relationship. So it's probably less likely that's going to happen. Like I say, the first step will always be to communicate with customers, but like I say, there are some nuances to look at in terms of your contracts, for those clauses I've mentioned, but also if you are in that sticky position, it's always best to deliver a smaller amount to everyone than, like I say, to prefer large amounts to your top customers and leaving those customers behind, which you may view as smaller customers, because as I've kind of seen it in practice, those smaller customers can sometimes become quite sort of forthcoming if obviously they have sort of less supplies than the contract states.
Yeah, thanks very much, Dan. It's interesting you say there about the good faith aspect being the US dominated term. It's interesting from your point of view, Laura, now having with Meet Business Women now landed in the US recently. So, okay, Chris, if we could move on to you, please, with the next question. What sort of employment claims are we now seeing arising out of the pandemic? If we could just have your input on that.
Okay. Thanks, Bryn. I mean, obviously the onset of this global pandemic introduced employment lawyers and for the employment tribunals as well. And the reality is that we are seeing obviously a lot of health and safety related aspects with genuine concerns. Some people are refusing to, some people.
I think we're experiencing a few technical issues with Chris there. Sorry, Chris, we lost you briefly. There was a freeze. If you could just repeat what you were saying there.
Sorry, right. Let me just swap.
We're all good now.
Okay, thanks. And right, sorry, I'll start again then. The onset of the global pandemic quite clearly has introduced a whole series of new problems for employment lawyers to advise upon. What we've certainly seen since the onset of the pandemic is obviously lots of redundancy related claims. They're obviously very much at the forefront at the moment. A lot of health and safety related claims, where obviously there are all sorts of issues about when is it safe for employees to return to work, when can employers insist on them returning to work, what would be a reasonable justification for not going back to work. We've also seen a lot of whistleblowing claims. Obviously when the first
We've lost
paid work. You cannot undertake any paid work. I'm still here.
We lost you briefly there again, Chris. But let's just move on from Chris in light of the problems that we're getting with the screen there. In terms of the health and safety field and coming on to myself, we had a question submitted in relation to complying with accurately. How does a business continue to comply accurately with regulations when there's so much change? And obviously, you know, the meat industry in particular is a massively regulated industry, and it's incredibly difficult to keep up to date with things. We have to remember, obviously, ultimate responsibility lies with the business and its directors to assess significant health and safety risks, and that the key thing is that's a non-delegable duty to protect. But equally, obviously, there are duties and obligations on employees as well. The HSE website obviously is extremely useful for guidance and instruction, and also it was very useful to check government guidance in relation to various matters in terms of the industry and meat processing plants, etc. And there's also a plethora of online articles available, and in particular also for the meat industry, there's of course the Food Standards Agency. With the bigger organisations, obviously, it's likely that you're going to have a health and safety officer employed, so they can obviously give timely updates and keep the business up to date. For the smaller businesses, that's obviously going to be a little bit more difficult. So essentially, yeah, it's not easy, but it's a question of checking online and in particular referring to the HSE website. Robin, could we come back to you again, please, with a matter? A question here: how can we protect our business against the risk of a customer owing us money going bust? That's going to be an interesting one to.
Yeah, I suspect that's going to be relatively commonplace, sort of as we come out of the pandemic. This actually leads on quite nicely from Dan's excellent answer. We're talking about sort of the contract position, because under a recently sort of introduced bit of legislation under the snappy name of Corporate Insolvency and Governance Act 2020, that effectively changes the position slightly in relation to what in law we call ipso facto clauses, but which effectively would commonly be treated as termination clauses. So if you look at most people's contracts, they will normally have a provision in there which says that if you, the person I'm dealing with, goes into any form of insolvency, then I will have the right to terminate this contract. Now, under the Insolvency Act, as originally existed, which is 1986, under the Insolvency Act 1986, there's certain protection which provides that key utility suppliers such as gas, electricity, water, etc., don't have the right to rely on such termination clauses. But commonly speaking, any other supplier would have the right to apply a termination provision, effectively because obviously you're looking to protect your supply and don't want to build up unnecessary debt. And the reality is, of course, in the vast majority of insolvencies, it's likely to be a liquidation. Therefore, there won't be an ongoing trading relationship in any event. However, the Corporate Insolvency and Governance Act, or CIGA, has introduced effectively a suspension of the right to rely on termination provisions to key suppliers. The difficulty with all this sort of legislation is that the word key supplier is very much open to interpretation. And it's perfectly possible, for instance, that that a business that one of our members supplies to is such that our member is a key supplier and therefore may not necessarily be able to rely on the onset of insolvency to terminate the contract. Now, bearing in mind that insolvency isn't always liquidation, it can also be an administration and a continuation of the business, or it could be a moratorium created by entering into a corporate voluntary arrangement, for instance. So the scope for bargaining has somewhat reduced. But the reality is that while you don't necessarily have the right to terminate the ability to supply, you are entitled to be paid for that supply, and therefore there's nothing to stop you requiring that there are much stricter payment terms. So it comes down to communication. My experience in sort of supply chain failings and customer chain failings is that that people do not talk quickly enough about something. They'll get a notification that they're going into some form of insolvency. Customers are often embarrassed about going into some form of insolvency. They see it as a personal failing. You know, it's fair to say 99% of companies that fail don't fail because the directors have set out to make it fail. It fails for a number of reasons. So, you know, there should be less embarrassment about that. There should be more communication, but there often isn't. As soon as you receive a notification, you need to speak to your contacts, find out exactly what's going on, find out what their plans are, find out whether you need to rely or try and rely on any kind of right to terminate. Possession's 9/10. My view is, if a company goes into liquidation, don't let your goods leave the shop floor unless you've got a very clear idea about how you're going to get paid. So that's my view. So it comes down to exactly the same effect as cash flow, which is communicate, find out what's going on, but quite often sort of a thing like administration ties your hands because there are moratoriums to effectively stop people taking particular actions and to protect the business and give it an opportunity to survive the administration and carry on as a going concern. So seek advice from your accountant, seek advice from your solicitor, preferably seek advice from us. But the reality is, make sure you do something about it. Don't sit on notices, be proactive, because you will more likely than not be aware until you receive the notice that there is a likely onset of insolvency. Although, if you look at the cash flow and have the necessary cash flow intelligence and the communication within the industry, I think you'll find that there were plenty of signs there to start with. They just wouldn't have been picked up.
Yeah, thanks very much, Robin. Yeah, really timely and key advice, especially in the current climate, obviously. Chris, if we could come back to you, you were a little thwarted initially with some technical issues there, but we were talking about the employment claims and what we're seeing now in terms of arising out of the pandemic. If you could just perhaps pick up on that.
I'm very sorry about the technical issue. I don't know what happened there, but according to my computer, I was still connected, but there we are. So I'm sorry if you've heard some of this a few minutes ago, but yeah, what I was saying was that in terms of obviously the global pandemic, it's a totally unprecedented situation. So as employment lawyers, as employers and employees, we're seeing claims now that we haven't really seen before. The key ones clearly are redundancy. We're seeing a lot of redundancy claims. We act for employers and employees. The redundancy claims introduce new aspects for employment lawyers, because a very fundamental question is you can't make people redundant unless there's been a business closure, unless there's been a workplace closure, or the work is diminished. But of course, the furlough scheme introduced this new concept of the government subsidising or underwriting the payroll. So a key question for employment lawyers is, when is it appropriate to commence redundancy consultation? Because of course the workforce are going to say, you don't need to make me redundant during furlough. because the government is paying the wages. It's not costing you anything. But as we're coming out of furlough now, clearly the furlough contribution is being reduced. The problems with the economy are going to become more and more clearly in focus. So we are seeing more and more redundancies. So that's obviously the first key element that we're seeing. We're also seeing what I term health and safety issues now in the Employment Tribunal. Some people, understandably, are reluctant to go back to work. Some flatly refuse to go back to work. Some employers take the view, if I require you to come back to work, that is a reasonable management instruction. We've taken such precautions as we think are appropriate in accordance with guidance. I'm telling you, you've got to come back to work. So there's lots of standoffs at the moment between employers and the workforce. The third category that we're seeing an increased amount of is whistleblowing claims. Because obviously under the furlough scheme, when it was first introduced in March, people were told you can go home, you mustn't do any paid work from home. And on that basis, we, the employer, will claim the furlough grant. But there's been, unfortunately, and inevitably to some extent, some attempts to exploit the scheme, which then have resulted in employees making whistleblowing disclosures, either to their employer, which you're entitled to, or to HMRC. And we understand that the HMRC hotline has been very, very busy, and HMRC have already started handing out fines for attempts to exploit the scheme. So those are the key things that we're seeing. It's also worth me mentioning that even before the pandemic hit, there was quite a considerable backlog of cases in the Employment Tribunal. The pandemic, of course, has not helped. And depending on which Employment Tribunal your case is proceeding in, makes an enormous difference. I understand that Central London still isn't properly operational at all, mainly because of staff being very reluctant to use public transport to get into Central London. Some of the regional centres are much better. I'm very pleased to say that Cardiff is probably one of the very, very best. And that's probably related to the fact that the current president of the Employment Tribunal was a Cardiff solicitor. So he obviously made sure that Cardiff was well set up with all the resources. So it has been possible there to arrange virtual hearings. And I've been able to do various virtual hearings using the technology. It hasn't failed me during a hearing yet. It's only failed me during the webinar this morning. So we can get on with things. But the reality is that even with the best employment tribunals at the moment, if you're involved in a case that is likely to occupy the tribunal for 5 days, you're probably going to have to wait for at least a year before that would be heard. So it's certainly a factor to take into account in relation to all employment tribunal claims, that whether you're the employer or the employee, you're going to have a very long wait before you get a determination from the Employment Tribunal. So one of the things I'm advocating very clearly is employment mediation as an alternative to a protracted wait and a journey to the Employment Tribunal.
Yeah, sure.
Thanks, Bryn.
Thanks very much, Chris. Just for myself then, another health and safety question. What would be your key advice for the workplace risk assessment? I'll keep it short, sharp and snappy really. It's absolutely fundamental, obviously, risk assessments and appropriate risk assessments. They need to be bespoke. It's really important that you move away from generic standard-based assessments. There are a lot of them available online. It needs to be, specific to your business. You are best placed to understand the risks with the business more so than anyone. And it's really important also that it's based on meaningful engagement with the staff. You need to ask yourself before you conduct them, who is doing what and how, where are they doing it, why are they doing it, and what they're using. But the key takeaway, as I say, is the fact that it's bespoke and specific to the undertaking and the workplace in which the employees are obviously engaging.
I've just seen one quick question, if you'd like me to answer that. There's a specific employment question coming. Thank you. Rachel has asked, can an employer force you to go back to an office if you're living with an individual who's classified as high risk, e.g. a lung condition? The straightforward answer to that is that it sounds as though that employee is living with somebody who's shielding. And if you're living with somebody who's shielding, then of course there are particular requirements. From an employment perspective, first of all, is that a reasonable management instruction, just in the most general terms, for an employer to insist that an employee goes back to work when they're living with somebody who's shielding, or is at high risk? It's a very subjective question. It depends very much on the circumstances, and of course it may be that that employee actually can perform all or part of their role from home or remotely anyway, in which case I would say, as a general rule, then the employer should allow that concession. The interesting point from an employment perspective here is that there is something which a lot of people forget about called associative discrimination. And what that means is, if you as an employee are living with somebody who is themselves classified as disabled under the Equality Act, then you as the employee might be able to say, you are trying to impose a detriment on me, you are trying to force me to come back to work at a time I say it's unfair and it's unreasonable because of my association with that person who qualifies under the Equality Act as disabled. It gets a little bit more complicated because a disability under the Equality Act, which then gives you the protection, is a very closely defined requirement. So it depends on just how bad the lung condition is. If it qualifies as a disability, because that person is unable to carry out day-to-day activities, then if it qualifies as a disability, then by association, the employee might be able to claim discrimination protection, which then means that the employer is then under an additional duty to make reasonable adjustments to assist with that disability, even though it's not actually the employee's. So yeah, there may be redress there. But so that's just obviously a general answer without knowing the specifics.
No, that's really, really interesting advice. So thanks very much for that, Chris. I think we're sort of nearing the point where we're running out of time for the Q&A session. There are details available online for the speakers for everyone to in order to get in touch to obtain further advice. Hope you obviously all found that useful. And back over to you, Laura.
Thank you so much. I've learnt loads there, and the biggest thing that I've scribbled down is that lawyers and solicitors don't read the small print either, which makes me feel a load better. So that's brilliant to hear. It's, as you know, it's the first time we've tried anything like this, and it's great that we've recorded it and we can share it with our community too. So huge thank you to you all for giving us your time today and answering all the questions that the delegates had. So thanks again. In terms of Meet Business Women, our next event is on the 13th of October. It's our UK and Ireland conference. If you have a ticket for that, you'll have been contacted already. If you don't, then we'll be putting details on our website in the next day or two. So thank you so much, and as ever, feedback is more than welcome. So I'll send a link out to the recording probably tomorrow, and if you've got any feedback, please let us know, and I'll include the contact details for the HCR team. Thank you so much. Thank you. Bye.
Thank you. Bye-bye.
Bye. Bye.